Good morning, everyone. Thank you very much for coming this morning. I'm Michael Green, the Clerk of Green's List at the Bar. Our topic this morning, which is 10 most common faults, is it, Peter? I forget, in cost agreements, and our presenter is Peter Lovell. Brief introduction of Peter. Peter is an experienced practitioner. Peter is an expert in the area of legal costs, which has happened really more by happenstance than any, I think, planning on Peter's part, and hence he brings a lot of expertise to what he talks to us about this morning. What I'd like to say on Peter's behalf, so that to try and overcome pigeonholing, which happens to all barristers, I think we tend as practitioners to have barristers in our mind, a certain barrister for a certain thing, and people can be pigeonholed. Peter is in fact a commercial barrister. His practice is far wider than just legal costs, and therefore whatever expertise you see this morning brought to this question of costs, he also brings to a normal commercial practice. So please welcome Peter Lovell.
Thanks, Michael. You'll see from my paper that I have endeavoured to be as practical as possible, and some of you may be disappointed to see that there's no reference to cases or case citations. Others of you may be delighted by that fact. So this paper has come about because of, I guess, my frustration in seeing solicitors' cost agreements being torn apart by the Cost Court and put in the bin. Usually or sometimes I should say, I'm often the person doing the tearing up, representing the poor, aggrieved, struggling former client. But on the other hand, there are times when I am trying to, I guess, rescue the hard-working solicitor and make sure that they're paid pursuant to the costs set out or the internal rate set out in their cost agreement. And often I find it very frustrating that I see the same errors over and over and over again. So this paper came about quite recently, which is why it's quite short, because of my frustration, and I spoke to a small group of solicitors elsewhere, and then it's emanated into this particular topic this morning. One of the things I should commence by saying, and some of you may know this and think that this is very trite, but cost disclosure, your disclosure of your cost rates and your cost estimates under the Legal Profession Act is mandatory. You must do it, whether you have a cost agreement or not. And cost agreements are purely discretionary. You do not have to have a cost agreement. If a client walks in off the footpath, you do work for them. You don't need to sign them up with any sort of cost agreement unless you want to recover some sort of rate that's higher than you would otherwise be entitled to under a court scale or the practitioner's remuneration order, or unless you're acting on, say, a no-win, no-fee type arrangement in personal injuries and so on, where you almost always have to have some sort of cost agreement as to the terms of success and otherwise. So you would have a conditional cost agreement in those circumstances. So please note that cost agreements are discretionary, and cost disclosure and cost estimates are mandatory. Now, there's not much in the Legal Profession Act about cost agreements, quite frankly. It doesn't say much at all. But so it's amazing how solicitors manage to shoot themselves in the head when they produce one. My concern is that maybe some of you are not familiar with section 3.4.31, and I don't want to keep repeating section numbers because I find that quite irritating. But that section says in part, a cost agreement that contravenes or is entered into in contravention of any provision of this division is void. Now, there's not much in the relevant division, which is Division 5, but all I have to do, and I often do it quite easily, is find some little fault in, let's say, your cost agreement, and it's in the bin. Simple as that. Now, you might think, oh, well, so what? I can at least recover costs on the relevant default scale, the relevant court scale or the PRO, etc. But then you'll find that the rates pursuant to that scale are often quite low. Not necessarily so, but often quite low. And by the time you get hit with the penalties that the cost court will apply at the end of a taxation because of your non-compliance, by the time you pay the other side's costs of the cost review, etc., you'll find that you recover very little money. In fact, the last two matters I've had, one this week and one 2 weeks ago, this week's solicitor lost $25,000. The one 2 weeks ago lost $37,000. And there was one I had about 10 months ago where the solicitor lost $74,000. So if you want to do all that work for nothing, fine, that's up to you. It's just a matter of whether you want to comply with the legislation or not. So with that perhaps short introduction, I'll get into some of the critical faults, some of which you might find ludicrous, as I do, but they're there. This is what I see in the cost court. I've called this topic 10 critical faults. I've given you about 13 or more just so you get your money's worth. Anyway, the first fault is that the cost agreement is unclear as to who is the paying party. It's been unclear to the degree that I've seen on some occasions where the paying party is not even named in the cost agreement. It is blank. The solicitor or the relevant firm has probably got their secretary to pump out something from the computer system, and they fill in bits and pieces and they make sure that their hourly rate of $880 an hour, including GST, is all recorded, but they don't put in the name of the paying party. So it's completely unclear as to who is intended to be bound by this cost agreement. And in case you're wondering, a cost agreement is a contract. It is a contract like any other contract, so it will be interpreted and construed and enforced like any other contract. There are other confusions, for instance, where you might put in somebody's name and it turns out they're a director of the relevant company you're doing work for, and of course they argue later on, after you've done 3 years' worth of work, that they didn't intend to be bound personally. They were just signing this cost agreement as director of the company, and of course you've been acting for a company that's gone into liquidation. So then there's more confusion about those issues. If you wish to bind a third-party payer, i.e. a person that's intended to be paying the costs, even though they're not the direct client, so to speak, then you will need to make sure that the cost agreement names that third-party payer, and you also must give full cost disclosure to that third-party payer. Now, when I explained that type of oversight to my very bored wife, who's sick of hearing me talk about it each night, she can't believe that people who call themselves lawyers make these errors. And I know we're not all perfect, least of all me, because I've got a typo in the next one. It's just mind-boggling that these sort of oversights actually occur in court. They are brought up in court. So the court, the costs judge, knows who you are and what your what your, I guess, diligence rating is on that basis. Okay, the second issue is that often the cost agreement is not signed by the relevant paying person, be it the client or a third-party payer. Now, if you race to my typographical error at the end of item 2 where it says 2.4.26, that should be 3.4.26. I'd like to say I put that in deliberately, but I didn't. You will see that that section or that subsection allows a cost agreement to be accepted by conduct. So you may in fact have the situation, which is quite common, where you send off the cost agreement to your client and it says please sign, return, etc., etc. If you do not do that, we will continue to act on the basis of you providing us with further instructions, and accordingly the cost agreement that will be, those further instructions will be treated as a form of acceptance. That's actually okay. There's nothing specifically wrong with that, except if you are dealing with a conditional cost agreement, because a conditional cost agreement, say in a no-win, no-fee situation, I've mentioned this briefly down in section 8 or part 8 of my paper, and I'll come to it later on. I don't want to dwell on it too much now. If you are entering into a conditional cost agreement, it must be signed by the client. So some cost agreements, not being conditional cost agreements, can be accepted by conduct, i.e. the provision of further instructions and so on, but conditional cost agreements must be signed. Okay, point 3. This is a cute one that I come across quite often. You've got your cost agreement, you've named the relevant party who has to pay, it comes back signed, let's say, but you haven't bothered to set out in your cost agreement the scope of work that the cost agreement is intended to apply to. It often arises in circumstances where the relevant firm or lawyer is acting for a client in a number of matters. You might be acting for an institutional client or whatever, and it doesn't actually say that the scope of work to which this agreement relates is, let's say, dispute about conveyancing matter at such and such address in Dandenong or whatever, or that it's to do with some particular commercial dispute that the company's having with BHP or whatever. So you need to set out what the scope of work it is that the cost agreement is intended to relate. Because otherwise, once we see in the cost court some sort of ambiguity, some sort of uncertainty as to what is it, what work is it that these rates in this cost agreement applies to, if we cannot answer that question, then it's likely to be thrown out as invalid, because it's like, as I said, like any other contract, it can be found to be void or invalid simply on the basis of uncertainty. Point 4, excuse me, point 4, solicitors seem to think that they can draft their internal scale of costs better than any court scale will ever read. So they sit down and come up with all sorts of little charts and whatnot, saying that any work that's done by a partner will be so much an hour, including GST, and any work that's done by an employee solicitor will be at such lesser rate, and some other person, the tea lady, will be charged out at so much, and all the rest of it goes on and on and on. And then sometimes, quite often, it will say Any other work will be charged in accordance with the Supreme Court scale or the PRO or whatever, it doesn't matter. So immediately, even though the solicitor has put a great deal of work into this ingenious calculation, immediately we have a conflict. Straight off the bat, conflict. Conflict between the internal rates that the solicitor wants to charge for him or herself plus staff and how they mesh or merge with the applicable court rate or PRO as the case may be. And of course, I think 99 times out of 100 they do not mesh and merge perfectly seamlessly together. So for instance, if the court scale or the PRO says that you can charge $50 to file a document at a court, and the solicitor's internal rate says something like any work done by Fred the partner is charged out at $880 an hour or part thereof, and it just so happens that Fred does the filing. Does Fred charge $880 or does Fred charge $50? That's the sort of thing I'm getting at. So the minute you have conflict is the minute, especially if I'm acting for the poor, aggrieved, downtrodden client, is the minute I start smiling in the cost court. So you need to make sure if you are going to do that sort of thing, which is inherently dangerous, you need to make sure that it is seamlessly merged in that way. Also, a lot of the rates I find are quite confusing. You look at the chart, say the hypothetical chart that's on page 1 of the, or say page 2 of the cost agreement, and those rates include GST. You look at the cost disclosure statement that's stapled back to front and upside down at the back of the cost agreement, and you find that the same rates are there plus GST, and so on and so forth, because nobody has bothered to make sure that the material is common throughout the entire document. And when I say the entire document, I'm including, in some instances, the mandatory cost disclosure, which some solicitors staple to their cost agreement and other solicitors say are part of and form the terms of their cost agreement, and I'll come to that later. Item 5, I know it's 7 years ago, so some of us may not be quite up to date, but the correct late payment interest rates are the cash rate target of the Reserve Bank of Australia plus 2%. So if you wish to, in your cost agreement, charge late payment interest in circumstances where the client doesn't get around to paying your bills promptly, you can charge late payment interest at the cash rate target of the Reserve Bank of Australia plus 2%. It is the cash rate target, it's not the cash target rate, and it is plus 2%, and it is definitely not the penalty interest rate plus any percent. It is definitely not the penalty interest rate. Now, I thought 2007 was about 7 years ago. I just cannot believe that that's the first thing I see in most cost agreements and indeed in cost disclosure statements, which invariably has not been brought up to date. So please just, when you finish watching Big Brother, just look at the LPA section 3.4.21 and regulation, these are legal profession regulations, 3.4.3, which sets out that rate and how it applies, because that rate varies. Unlike the penalty interest rate, that rate varies quite regularly. The other thing, point 6 is probably the most galling of the lot. You will see in in the Legal Profession Act 3.4.9 that you have to give various information about your cost rates and so on, but you also have to give clients information about how they can complain about your costs. Well, I think we are one of the few professions that in our work and on our lump sum bills and itemised bills and so on, that we actually have to invite people to complain about our costs. So we're really nice like that. But when we invite people to complain about our costs, we actually have to tell them what the deadlines are. We actually have to say that they can go and have a cost review, etc., in the cost court within a certain period of time. We actually have to tell them that they can go to VCAT and try and set aside our cost agreements, etc., within a certain period of time. If we are inviting them to go to the cost court to review our costs, please do not put in a reference to them having a 60-day time period. That, in fact, even under the old 1996 Act, it's 12 months. The cost court has now reached a point where I've heard murmurings, and I've mentioned this to some of you before, that where cost agreements and cost disclosure statements refer to 60 days instead of 12 months and refer to the old penalty interest rate instead of the cash rate target, there is a strong likelihood that you will be found to have conducted yourself in a misleading and deceptive manner. This is now heading towards misleading and deceptive conduct territory. And I am now, for the first time I must admit, starting to put in my submissions references to Section 18 of the Australian Consumer Law based on misleading and deceptive conduct. Just because solicitors do not keep themselves up to date on this point, on these points, I should say. Now, some people say, oh, we heard you talk the other day and you really scared us. Well, I'm not wanting to frighten you, but sometimes I feel like I have to maybe get you to think about it a bit more deeply than usual. Before we break, because we're only a couple of minutes away from 8 o'clock, I just want to mention quickly item 7. Item 7 probably really fits in more with conditional cost agreements, but I'll mention item 7 anyway. There's often a reference to there being a charge in a cost agreement. Solicitors like to do that to make sure that they get paid and that they have the client sign a cost agreement that contains a usual provision that the client's charging all his or her right, title and interest in all property wherever found and blah, 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 blah to secure costs, and the solicitor can lodge a caveat over any such property, etc., etc., etc. Well, if you have such a charge over unidentified property, then it is void pursuant to Section 44 of the National Credit Code. In case you're wondering where the National Credit Code actually is, because politicians like to hide all this sort of stuff, it's in Schedule 1 to the National Consumer Credit Protection Act 2009 of the Commonwealth. So that's the National Consumer Credit Protection Act 2009. So the code is Schedule 1 to that Act. So if you look at Section 44 of the National Credit Code, it actually says that charges over unidentified property, it's okay if you identify the property. So if somebody's grants a charge over all their right, title and interest, etc. in their property at 15 Smith Street, Fitzroy or something, that's all right, as long as you don't have a general unidentified. And it only relates to legal services that are provided on credit. In other words, this is a form of protection in relation to credit supplies. So that's why I say it applies more to conditional cost agreements, like no win, no fee type cost agreements, because you are, in those circumstances, providing legal services on credit. So if you are providing legal services in a normal manner where you're just being billed, sending bills out every month or so, then you might be able to escape Section 44 of the National Credit Code. So it's something to be aware of, and it's something that very few people seem to know about. So Michael, if we can break now, because from point 8 I'll go into the conditional cost agreements, which are slightly different, and then I'll drift back into some of the issues about cost disclosure and how they will impact on your cost agreements.